Hi everyone, welcome back to a new post today. Let's discuss the most important topic today for the day, and that's about the reference bench now considering the case of the Tamil Nadu governor, where the Supreme Court had in April 2025 spelled out a judgment where it defined the timelines within which the governor and the president must give their assent to the state bills or the bills passed in the state legislative assembly and sent for their assent. Now, this reference bench has a very important role to play, especially in the constitutional understanding of the country. It will not only lead to understanding of the executive powers with regard to the bills, but will also bring out it will also clarify many questions that the President of India had given under Article 143 of the Supreme Court, 143 of the Constitution to the Supreme Court. Now, under Article 143, the President of India can seek an opinion of the Supreme Court on important questions of law or fact which are of public importance. The exercise of this jurisdiction is discretionary upon the court. That is, the Supreme Court may not give its opinion or may give its opinion if it deems fit. Supreme Court reference bench, now a 5-judge reference bench headed by B.R. Gavai, began hearing the arguments with regard, began hearing the facts of the case with regard to the Tamil Nadu governor, which was spelled out in April 2025, and on based of the considerations, they will give their opinion to the questions which were asked by the President under Article 143. 14 of them were given to the Supreme Court. Now, the Supreme Court reference bench observed that the Supreme Court's move to grant deemed assent to the 10 bills of the Tamil Nadu governor, which he reserved since 2020, was only to resolve an egregious situation. The word egregious means very outstandingly bad, appalling. That's what it means. So this situation created by the state governor that sat on the bill since 2020, spanning almost 5 years, led to the Supreme Court to grant deemed assent to the bills. The reference bench ruled that it did not intend to pronounce a judgment on the Tamil Nadu governor case, but only wanted to look into the facts of the case so that it can give a correct opinion for the questions posed by the President of India under Article 143 of the Constitution. The reference bench also, the Attorney General, now who is representing the Government of India, said that the governor had his own reasons to keep the bill pending, and which was within the powers exercised by him under Article 200 of the Indian Constitution. And under this article, he was not bound to act on the aid and advice of the Council of Ministers along the Chief Minister while exercising his discretionary power. The Attorney General said that the Constitution gave the powers to the President and the Governor the power to withhold the bills that they found to be suspective of constitution or even unconstitutional. The Solicitor General, that is the law officer who represents the governor, told the court the reference must not go into the facts and just give its opinion merely. Now, the reference was issued by the President, as I told you, under Article 143 of the Constitution. A month ago, 2-bench judge of Supreme Court had on April 8th spelled out a judgment in the Tamil Nadu governor case, and this plunged the constitutional silence where it spelled out fixed time limits for the President and the governor to give their assent to the bill, withhold their approval, or even reserve the state bills for consideration of the President under Article 200 and 201. Now, this was a very important judgment because the Constitution does not specify any timelines within which the President has to give his assent to a state bill or even the governor as well. The division bench headed by Justice Pardiwala also invoked the special power under Article 142 to grant deemed assent to the Tamil Nadu governor's bills. But usually the governor gives his assent to the bill only when the governor at the state level and the President at the center give their assent to the bill do they become laws. But in this case, the Supreme Court used its special power to provide justice under Article 142 and gave assent to the Tamil Nadu bills, and it held that the laws which remain pending with the President or the governor beyond a specified period of 3-time deadline would be deemed to be approved as passed. So this was an important landmark case, and that judgment of the Supreme Court, however, it was seen by many as intruding into the executive domain and also violative of the Constitution distribution of powers as well. Venkatramani argued that the court could not have used its extraordinary power under Article 142 to supplant the substantive law in Tamil Nadu. The top court officer said that the constitution did not impose any time limits on the president and the governor while dealing with state bills, and contended that the Supreme Court use of power under Article 142 violated the constitution and also the basic structure of the constitution, which divides the power between the executive, legislature and the judiciary separately. There were 14. The bench of Pardiwala and Mahadevan in April 8, 2025 declared the Tamil Nadu governor's decision to withhold the 10 bills as illegal, arbitrary and fixed a 3-month timeline for the president to clear the bills. President Draupadi Murmu subsequently issued an advisory opinion under Article 143 of the Constitution to know whether timelines can be imposed on the President's power and the Governor's power while deciding state legislature bills, when the Constitution itself does not mention anything like this. The Solicitor General Tushar Mehta, appearing for the government, said imposing timelines on the Governor and the President would amount to one organ of the government assuming the powers of the other organ and therefore violative of the Constitution. However, let me tell you that the President's reference to the Honorable Supreme Court is a watershed moment in India's constitutional journey. The 14 questions have now instigated profound constitutional dialogue on the delicate balance of powers between the executive and the judiciary, particularly between understanding the legislative assent process. The outcome of the reference will have far-reaching implications. It is poised to clarify constitutional boundaries within which the President and the Governor shall exercise their assent powers, potentially leading to a more defined and also predictable legislative process. This constitutional dialogue may also serve as a catalyst for the Parliament to consider legislative reforms, codifying clear procedures and timelines within which the bill has to be given assent, therefore reducing the ambiguity that has always led to conflict between the executive, that is the CM, the Council of Ministers and the Governor, and at many states. Ultimately, this episode shows India's dynamic constitutional democracy, and also it shows how the constitution can be amended from time to time to adapt to both the changes in the governance and also whenever there is a conflict that arises. And this will also lead to promotion and preservation of the foundational principles on which the Constitution of India has been developed. So the landmark judgment of Tamil Nadu governor's case in April 2025, and now the President's reference will definitely give clarifications about the legislative process in India, and also try to deal with conflicts that have arisen because of the powers used by the governor to withhold assent and also to preserve the bill for the President's reference, therefore dealing the legislative process mainly at the state level where it is seen. So these are the most important points I thought I should be discussing with you all. If you did, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in my new post. Until then, it's very happy learning.